When a contract breaks, the law doesn't view it as a moral failing or personal betrayal. It treats the breach as a cold economic calculation. The objective of contract remedies is strictly mathematical. A court seeks only to place the injured party in the exact financial position they would have occupied had the promise been kept. Because the law assigns no moral weight to a broken contract, you cannot recover punitive damages. No matter how willful or malicious the breach, a plaintiff cannot demand millions of dollars out of spite. The court will only award what was actually lost. To measure that loss, courts apply three distinct frameworks: expectation, reliance, and restitution. Surviving a contracts exam requires abandoning the instinct to punish the defendant. A breach of contract is simply an algorithmic equation that needs to be balanced. The default baseline for that equation is the expectation interest, commonly called the benefit of the bargain. The formula is straightforward. Total damages equal the actual losses caused by the breach, plus the gains prevented, minus any costs the plaintiff saved because they didn't have to finish performing. We see this formula clearly applied in Hawkins v. McGee. A doctor guaranteed a patient a 100% perfect hand through an experimental skin graft, but left the patient severely disfigured. The court didn't look at the injury in a vacuum. It calculated the exact mathematical difference in value between the promised perfect hand and the resulting damaged hand to isolate the specific loss caused. The court explicitly excluded the pain and suffering inherent to the surgery itself from the damages. That pain was an expected cost of the procedure the patient agreed to, not a loss caused by the breach. The expectation formula encounters a strict limit when literal performance creates economic waste. In Jacob and Youngs v. Kent, a builder used the wrong brand of pipe in a new home. Tearing down the completed masonry walls to replace the pipe with the contracted brand would have cost an astronomical sum of money. The replacement pipe would have added exactly $0 to the home's market value. To avoid overcompensating the homeowner with a massive windfall, the court refused to calculate damages based on the literal cost of replacement. Instead, they awarded the difference in market value, which was nothing. Expectation damages protect the objective economic value of an agreement. Courts will not mandate astronomical waste simply to enforce a technicality. The expectation formula relies on objective numbers, but it breaks down entirely when the gains prevented, the projected lost profits, are completely unprovable. When expectation is too speculative, courts hit the rewind button and award reliance damages. This reimburses the plaintiff's out-of-pocket sunk costs, returning them to the exact financial position they were in before the contract ever existed. Alternatively, courts can use restitution damages. This framework ignores the plaintiff's losses altogether and operates strictly as an extraction tool. It strips the breaching party of any material benefit they received, preventing unjust enrichment. Each measure serves a distinct purpose. Expectation looks forward to the future. Reliance looks backward to the past. Restitution targets the defendant's pockets. The expectation baseline is only the starting point. To successfully recover those damages, a plaintiff's claim must survive three strict legal filters. The first is foreseeability. In the 19th century case Hadley v. Baxendale, a commercial flour mill was forced to shut down when its steam engine's crankshaft broke. They hired a carrier to transport the broken shaft to be copied. The carrier negligently delayed the shipment for several days, keeping the mill closed and costing the owners massive business profits. As the text from this opinion outlines, the court ruled the carrier could not be held liable for those lost profits. The mill owners never explicitly informed the carrier that the broken shaft was the sole component keeping the entire operation running. The ruling established a permanent distinction in contract law. General, direct damages flow naturally from a breach and are always recoverable. But special, consequential damages, like the mill's lost profits, can only be recovered if the breaching party had specific reason to foresee them at the exact time the contract was made. You cannot hold a breaching party liable for a disastrous chain reaction of indirect harms if they had no reasonable ability to predict it when they signed the agreement. Even if a loss is foreseeable, it must pass the second filter, reasonable certainty. Courts require mathematical rigor, barring damages based on hopes or hypothetical business plans. In Proctor v. United States, a plaintiff sought massive lost profits for a business enterprise that failed to launch due to the government's breach. Because the venture was an unproven startup with zero historical financial record, the court denied the long-term lost profits entirely. The court also identified a critical mathematical error in the plaintiff's claim. As this source document details, the going concern value of a business already accounts for its future profit-earning potential. Awarding the sale value of the business on top of its projected future profits constitutes an impermissible double recovery. Contract law operates on objective economic realities. If a plaintiff cannot prove the extent of their loss with hard data and reasonable certainty, their damage award drops to zero. The final filter is mitigation, or the doctrine of avoidable consequences. A victim of a contract breach cannot passively sit back and watch their damages accumulate. They have an active duty to minimize the fallout. In Rockingham County v. Luton Bridge Co., the county canceled a bridge construction project. At the time of cancellation, the builders had only incurred minor expenses. As this case excerpt notes, rather than stopping, the builders ignored the repudiation and proceeded to pile up damages by completing the entire structure. The court denied the builders' demand for the full contract price. By intentionally finishing a bridge the county explicitly stated it no longer wanted, the company failed its passive duty to halt work and minimize waste. We see the opposite behavior in the Hessler case, which illustrates active mitigation, often called cover. When a dealership breached a contract for a highly anticipated limited edition Plymouth Prowler, the buyer immediately located and bought a replacement vehicle on the open market. Because the buyer reacted efficiently to a restricted market, the court awarded him the full price difference between his original contract and the more expensive replacement vehicle. There is one major exception to this mitigation rule: the lost volume seller. In National Controls versus Commodore Business Machines, a buyer breached an order for 900 electronic scales. The manufacturer easily resold those exact same scales to a third party. The buyer argued that the resale fully mitigated the damages. The court disagreed. Because the manufacturer had a factory with excess production capacity, they had the resources to complete both the original order and the third-party order. Reselling the units did not replace the lost profits from the broken contract. Contract law rewards commercial efficiency. It protects a lost volume seller's capacity to earn multiple profits, but it fiercely penalizes any victim who intentionally aggravates their own financial injury. Synthesizing these rules creates a definitive flowchart for analyzing contract remedies. First, identify the breach. Second, calculate the default expectation interest. Third, check for economic waste. Finally, run that baseline through the three filters: foreseeability, certainty, and mitigation. As demonstrated in Madare v. Stevenson, you must strictly exclude collateral costs. Attorney's fees, personal travel, and cumulative damages are off the table, unless explicitly authorized. Contract remedies are not a mechanism for justice or punishment. They form a strict algorithm of economic restoration, constrained entirely by what the parties knew at formation and how efficiently the victim reacted to the breach.